Good evening. My name is Dixon QC and I'm President of Liberty Victoria, and I'd like to welcome you all here tonight. It's a delight to see so many people taking such an interest in community safety and crime and punishment. We have a wonderful panel here tonight. We have Professor Peter Norden, who many of you will know, who is currently Adjunct Professor at the School of Global Studies at RMIT, has had long experience in both academia and practical experience with offenders. He was Vice-Chancellor's Fellow at University of Melbourne. He served as a chaplain within the Victorian prison system, including at Pentridge Prison from 1985 to 1992, was Policy Director of Jesuit Social Services and a National Board Member of ACOS. And he's had a particular interest in issues of social disadvantage and offending, and he's also, of course, an officer of the Order of Australia. John Coldrey QC was a member of, or made a member of the Victorian Bar in 1966, took silk in 1984 and became Director of Public Prosecutions at that time. And then, having served in that office for some 6 years, took a position on the Supreme Court of Victoria and served as a judge until April of 2008. He's currently chair of the Victorian Institute of Forensic Medicine and maintains a great interest in the criminal law. And we also welcome Attorney General Robert Clark, who's the member for Box Hill and is one of our longest serving members of Victorian Parliament. He's unapologetic in his position about crime and a tough on crime stance, and he'll explain his views about that to you tonight. He's also a married man with 2 children who are in their 20s. So that's our panel, and I thought I'd come firstly to Professor Peter Norden to get some insights about crime and punishment and offending based on his background. Peter, there's been much outcry in the newspapers and media recently about crime and so-called rising crime rates, violent offending, the ice epidemic, domestic violence and so on. Is it getting worse?
Look, I look back on 20 years working directly with offenders, which finished about 20 years ago now, and there were some terrible crimes committed, and I saw people in prison for them, committed through the 50s and 60s and 70s. They probably didn't have the same media monitoring as we have on serious crime now. So when a serious crime's committed, such as the Jill Meagher murder, it got national headlines for weeks, and it really shaped communities' views on community safety. But I think, the society's changing rapidly at the moment, and when society changes, you see symptoms of unease, so perceptions of crime is enhanced. We see evidence in domestic violence, we see concern about child protection. But there's a huge social change taking place at the moment, and that's when communities' perceptions of crime are accentuated because of a sense of unease and anxiety. But when you look at the statistics across the board, the crime rate in Australia hasn't dramatically increased for 50 or 100 years.
The criminal justice system is sometimes seen as the answer to all the problems with crime. Is it your view that it should be viewed as the answer to crime?
Look, I like to talk about the criminal justice system as a very blunt instrument in dealing with complex social problems. We don't know how to deal with crime and punishment, just as we don't know what food's good for us even in this day and age. So there's no simple answers, but having worked in the field directly with offenders for 20 years, I moved into another area, looking at prevention work, dealing with people who are long-term unemployed, who had mental illness and addiction, and then started seeing the concentration of crime coming from particular areas. So we started mapping disadvantage across the country by postcode with Professor Tony Vincent. But in the last 5 or 10 years, I'm more conscious of the need of the state and the federal government to create communities that are affordable and livable. Melbourne's increasing at 2% a year in terms of its population compared to the national population of 1.2%. A huge challenge for government in trying to actually create communities that are both livable and affordable. And when they're not, I saw the effects of Broadmeadows, Henry Bolte's initiative, I think, from early on, but so many young men and women came to prison from Broadmeadows because it was poor social planning. It was physical communities, but it didn't have the infrastructure. So we've got to be really careful as we respond to a growing population that we both have the physical infrastructure plus the social infrastructure to maintain a cohesive society.
So do you, based on your experiences, for example, a prison chaplain and seeing young offenders, is there hope? What are the things that might turn a young offender's life around at a critical period?
Look, it's no simple intervention. It's like the Northern Territory. If we just have truant officers, that won't produce a change in the Northern Territory. It might get kids out of their where they're living to school, but if they haven't slept all night, they haven't eaten. You've got to look at the complexity of issues that bring someone into contact with the criminal justice system. Of course, I'm not talking about the 10% or the 20% that are seriously criminal, that have got a commitment to a professional lifestyle. But we run the danger in Australia, not just Victoria, but throughout the country, of criminalising disadvantage. And where we've got an unemployment rate in Victoria of 6.4%. We've got a youth unemployment rate of 12% across the country, across the state. But in certain pockets, you'll see youth unemployment rate of 17, 20%. And then you've got long-term unemployment. So if you've got young people aged under 25 who are unemployed for more than a year or two, their lives are falling apart. They're going to move into areas like substance misuse, and they're going to have distress and anxiety that lead them in needing mental health care. So you've got to get in early. So you can work with individuals, and I did that for 20 or 30 years, but the real answer is real crime prevention and social planning that actually ensures that the community is not a divided community. In the United States, they failed to do that. They imprison, 1 in 100 citizens is in prison or under a supervision order in the United States. And look at the social divide in the United States. We don't want to follow along that line. But, Victoria's changing. If you look at Queensland, you look at the Northern Territory, the changes that are occurring there in the criminal law, I think our State Attorney General is like a lamb compared to the Attorney Generals in Queensland and in the Northern Territory, given the sorts of policies that are being implemented there in response, as they say, to community's sentiment or community feeling. But I say it's a perception of danger and violence. I've got 2 armed guards on my railway station. When I get home there at 9 o'clock tonight, there'll be hardly anyone there, and they'll have very little to do. But the community feels it's important, and they feel safe to have armed guards with capsicum sprays on every railway station in Melbourne. It makes them feel safe. So it is truly responding to a perception of danger, but in fact I think it's more a reflection, like domestic violence and like child neglect and abuse, of a changing society that runs the risk of being divided.
So where do you think Parliament and the courts should be directing their energies in terms of making the community safer?
Well, I think it's not good enough just to respond to the demand for housing at 2% a year. It's a terrible challenge to have to try to keep producing housing, but it's got to be livable. It's got to be affordable. I saw communities when I was doing a consultancy recently with the Department of Health here in Victoria, out on the outer east. There was nothing there. Houses were coming in, but there were no schools planned. I'm pleased that recently schools have been announced in some of these growth areas. But when I went out to, Cranbourne East, the only thing there was a Catholic secondary school, which was 3/4 built. So the Catholic Education Office had thought 20, 30 years ahead. But our political cycle works on either 3 or 4 year cycles. And a lot of the interventions that are really needed for good planning are 10, 15, 20 years. But unfortunately in Australia, in Victoria at the moment, we've got a very, tightly hung parliament with, depending on Mr Shaw in Frankston. So we're in a very unusual position, and we've been in the same position federally. But in order to really solve these problems, we've got to have social planning that looks at cycles of 10 and 20 years and aims to maintain a society where, yes, there's individual freedom and people, some win, some lose, but we can't afford to have a community that becomes divided and rely on the blunt instrument of the criminal justice system to keep it under control.
What about the concept of justice reinvestment, where in particular communities might be spotlighted for particular attention about problems with drugs or alcohol or youth suicide rates or ethnic problems?
Look, 15 years ago, as a result of the research that Tony Vincent was doing and I was project managing, we went to people like Tony Abbott, who then was the Federal Employment Minister, and we said, look, these are the kids we're working with. He came down, sit on his haunches for an hour and listen to these kids, and he said, nothing we're doing is touching them. So they started a new program that was really dealing with complex needs of young people, not expecting them to do 5 days a week straight away, helping them to deal with the whole complex issues of mental illness and drugs and perhaps a criminal record. But so often these young people who've got problems with mental health and drugs, they get shunted from one department to another. So again, we started a program called Connections, dealing with dual disability. And Rob Knowles was the State Minister at the time, came and supported it and acknowledged it. These are the sorts of programs that have got to be implemented, particularly where you've got very high proportion of people coming into the criminal justice system. You've got to get in early. Got to get in and make sure these kids stay at school, that they have role models. But we in the state system, we've got some good schools, but it's a very divided system. We've got the private school system, the independent school system, and some state government schools that are really good. But it's a two-tiered level of education. It's pretty predictable what the outcome of that's going to be in 5 or 10 years' time.
Criminal barristers are often in a position where they're begging the court for mercy for offenders and asking the court to consider the prospect that the young offender who may have committed a violent crime is capable of reclamation. Do you have any personal experience about reclamation of young offenders, and to what extent do your spiritual beliefs shape your views about the importance of mercy and forgiveness?
Oh. It's taken me back a little. Look, people do change, but Father Brosnan, who is far more experienced than I, 30 years in the nick, he said, what I've noticed after a quarter of a century, he termed this phrase, that people need after they leave prison is a place to live that's decent, a job they can handle, and most important of all, friends. But, imprisonment, particularly for young, vulnerable Australians, tends to disconnect them from their family and from their community. Their prospects for gaining employment once you've got a criminal conviction are almost zilch in this job market. If you're separated from your wife, your children, your family and your community, even for 6 or 12 months at a critical period of your life, there's a risk that that young person is going to create a criminal identity and go the other way. So, in Victoria over decades and decades, we've been pretty successful at diversion programs, both in the adult and the juvenile system. We've got to make sure that we sustain that because the problems that bring a young person before the courts, of course they need to commit a criminal offence, and of course there are victims involved, and I've worked with hundreds of victims. I'm not just on the one side. But we've got to actually maintain that very fine balance using the criminal justice system and recognising its limitations, but continuing to employ those diversions and alternatives to make sure that those young people, if they have contact with the criminal justice system, that it's a once-off, that they don't get drawn into this bottomless pit. Because if you spend time there, we used to call Coburg the College of Knowledge. And magistrates sometimes would say, I'll teach this young kid a lesson for 3 months or 6 months, or remand them for 3 or 4 weeks. In Queensland, they still put 17-year-olds in adult prisons, and they're proud to say they're not going to change it. They don't realise what happens to 17-year-olds. John Stark, when he was chairing the Sentencing Advisory Board prior to R.E. Freiberg, about 25 years ago, he was having hearings, and I was a witness, and he said, turn that thing off, meaning the tape recorder. This newfangled thing, turn that thing off. He said, now, Father Peter, he said, tell me, what does happen to these young men? Does it, what I mean, does it happen when they go into the prison or not? He was the most experienced sentencing judge in Victoria. He's trying to work out what happens to 17 and 18-year-olds if he was to send them down for 6 months or 12 months. I had to say to him, Your Honour, it does, yeah. So the alternatives have got to be there, and we've got to sustain the proud history that we've had in Victoria, very different from New South Wales. We've maintained an imprisonment rate of half of New South Wales for 50 years. How did we do it? Were we soft on crime? Did we have an outbreak of crime as a result? No. In Victoria, we had this rich uniform of diverse options, often provided by non-government agencies, that were able to flick these kids off where at all possible. In Queensland, they've said we're abandoning this idea of prison as a last resort for adults and juveniles. We'll send juveniles to prison to teach them a lesson. You watch what happens in Queensland over the next 10 years as a consequence.
I might go over to you at this point, John Coldrey, with your vast experience in the criminal law. Just starting at the beginning, some people might wonder, why is it that somebody can be charged with a pretty serious offence and still be released on bail?
Well, the reason for that is that you start off with the presumption of innocence. That's the basis of the criminal law. So if you have the philosophy that somebody is innocent until proven guilty, then you have to have pretty good reasons to lock them up whilst they're awaiting trial. Of course, there are circumstances where pragmatism clearly takes over. If there's a risk that that person will abscond, if there's a risk that that person might commit further offences if released on bail, if there's a risk that that person might seek to intimidate witnesses, then a pragmatic approach indicates that despite the principle of presumption of innocence, that person needs to be in custody until the trial occurs.
Do you sometimes, as a judge, have the anomalous situation that somebody's on bail for quite a long time, coming up to their appearance in court, and then they plead guilty at court, but over that period they've rehabilitated themselves and got themselves on track, and yet sentencing practice suggests that they should go to prison, having turned their life around?
Well, if they can convince a judge that they genuinely have turned their life around, and you've got to remember that turning your life around in the artificial confines of a prison is quite different to turning your life around with all the stresses and strains of living in the community. But if they have, then they'll get the benefit of that. You've also got the situation that if somebody is sentenced to a term of imprisonment, they are credited with the time that they have served in custody up until the time of sentence.
The justice system is very expensive to run, both in terms of funding the courts but also funding legal aid and funding the DPP's office. To what extent is it worth spending a lot of money on justice?
Well, depends where you start off. If you see the rule of law as an essential element of any civilised society, then one aspect of the rule of law is the criminal justice system. And if you want people to respect the law, then the criminal justice system has to work. The guilty obviously ought to be convicted and dealt with, but the innocent ought to be acquitted. And so if you want a civilised system of justice, then you have to spend money on it. You can't do it on the cheap.
And does that mean there should be some equality of arms in terms of defence and prosecution and funding for both those adversarial opponents in the criminal justice system? Well,
the Crown is always pretty well funded. They normally have experienced barristers appearing. You think that fairness would require that there should be some similar force of arms in relation to defence counsel. And if you're going to have that relative equality, then you have to pay for the defence counsel, and that has to be funded from somewhere, and normally it's funded through legal aid.
There's a bit of a perception out there that judges are out of touch and that they reside in something of an ivory tower, and that they are not meeting community expectations in terms of sentencing and understanding of the impact on victims of offences. What do you say about that?
Well, when I was first appointed to the bench, I've got to say my wife alerted me to two aspects of my life that she regarded as possible impediments to judicial office. She identified, and based on our domestic life, she identified, and I will summarise, chronic indecisiveness coupled with congenital procrastination. I told her I wasn't sure whether that was right or not, but I'd like a few days to think about it before making up my mind. Anyway, as to whether judges live in ivory towers, of course they don't. Judges come through the education system. They go to university, for example, they join clubs, they play sport, they have part-time jobs, they end up having families, most judges, children. The idea that they're somehow divorced from the community is a nonsense, and I don't really know where it comes from.
Is it a burden, sitting as a judge and having to deal with not only running trials but also sentencing people if they are convicted at the end of a criminal trial? Yes,
it's a very great burden. I don't want to sound like I'm doing special pleading here, but the work of a judge is quite unremitting. I can only talk about my experience, but that's duplicated by my colleagues. I used to work 4 nights a week, apart from sitting in court all day, and at least one day at the weekend. As for sentencing was the hardest aspect of judicial life. I'm quite prepared to admit that I would read victim impact statements and weep. I am quite prepared to admit that I would lie in bed at night, unable to sleep, trying to determine the length of sentences. And sometimes it might only mean a difference of 1 year to what the sentence would be. But that's 1 year that the person you're sentencing has to serve. So it is a difficult task, and sentencing is the most complex aspect of the criminal law.
Do you have a view that people that perhaps sit in court, such as jurors, and see the whole proceeding and the people involved, are perhaps better informed than when you just hear a sound grab on the TV news? Yes,
they are. I don't blame the media for this. They've got deadlines to meet. But let's take an example of a sentence for murder, where a judge might have given extensive reasons, maybe covering 20 pages, taking half an hour, 45 minutes, to explain why he or she is imposing the sentence that they do. You might pick up a newspaper and it might get 8 column inches, if you're lucky. You might turn on the television and you'll get a 2-minute grab. So, unfortunately, the community are not fully informed of the reasons for sentencing, and that, I think, leads to the misconception that judges are soft on crime. Why on earth would they be? We all live in the community. We all want a safe community. Why would any judge be soft on crime?
And is there a tendency to think that people that might stand in the dock of the Supreme Court charged with murder, for example, or manslaughter, all fit into a particular type and can be stereotyped as dangerous people, and you could predict beforehand that they might be the sort of people that would end up there?
Oh, no, you can't. I mean, anybody, given a certain set of circumstances, is probably capable of murder, probably any of us. Hopefully that would never occur, but the variety of humanity that appears in the dock in the Supreme Court is extraordinary.
And what's your view about the way forward in terms of community safety and the role of the criminal justice system? Do you agree with any of the things that Professor Norden has said about postcode crime and the need for governments to address the wider issues?
I don't disagree with anything that Peter Norden said, which is judicial talk for saying I actually agree with him. But look, if you're going to put people into prison, it's essential that you provide programs for them within that prison. Now, this is being done to some extent. There are programs there. You have to do, for example, a violence intervention program if your offence is one of violence. There are sexual offences programs. There are programs called cognitive skills. There are drug and alcohol programs, all aimed at rehabilitation and aimed at sending the person back into the community better equipped and less likely to reoffend. But given the cohort of people in prison, there's obviously a lot of reoffending.
And you sat on the parole board for a period of several years. How important is parole to the release of prisoners back into the community? What purpose does it serve? And given recent high-profile cases, have we been mismanaging, or what's your views about that?
Well, we certainly haven't been mismanaging parole. I think some of the publicity in recent times did the parole board a grave disservice. Let me just fill you in very briefly. There's about 24 people who comprise the parole board. A number of them are judges or retired judges. Then there's a number of community members. And during the time I was sitting, there was, for example, a respected Aboriginal elder, there was a psychiatrist, there was a neuropsychologist, there were social workers, there was a woman who'd obtained a master's degree in how to manage offenders in the community, and two of my colleagues, one her husband had been murdered and she sat on the board, and another of the members was a Deputy Commissioner of Police. And to suggest, as has been in some quarters, that community safety was not paramount for the parole board is extraordinary. I might say the board sits in panels of 3, so that that's not you don't have 24 people sitting, but I don't think the public understood how the parole board operated. The media didn't do much of a job, or maybe the parole board itself should have done a better job in explaining its operations. But to get back to your question, parole is absolutely essential. Absolutely essential. If you want to warehouse people and let them out in the community unsupervised and uncontrolled, then the chances of them reoffending are enormous. But if you want to transition them in the community with part of the sentence still hanging over their head, have them supervised, have them obey a set of conditions imposed by the parole board, then you've got much more chance of them succeeding in re-establishing themselves in the community. And these conditions involve reporting, they may involve abstention from alcohol, they may involve drug testing. There's a whole plethora of conditions that can be imposed on people who've been granted parole.
So something of a carrot and stick approach. Professor Norden, do you agree that the parole board has an important function to play in terms of releasing offenders back into the community?
Look, I think to suggest that to deny parole to up to 1,000 offenders, as has occurred in this state over the last 12 months, and suggest that that's a way of protecting the community, and then 6 months later, 12 months later, 18 months later, releasing them, as John has said, without any supervision, any control over them at all. I mean, what's being protected is the reputation of the government here, and Ian Callinan's recommendations were good corporate advice for the government, but the people who are... because he suggested only people should be released on parole who pose no risk. So if you haven't got accommodation, you pose a risk because you're going to reoffend. And you'll be held in... They're not all the Adrian Bailey types. Most of them are not at all. So if you've got nowhere to live...
We hope not.
If you've got nowhere to live and you're an 18, 19-year-old, you get parole denied, you stay in for an extra 6 or 12 months because you've only got a 2 or 3 year sentence, and then you're released, and the prison officer used to say, "You'll be back, son." And sure enough, someone who doesn't have any support in the community, who's vulnerable himself, he's sure to reoffend if he doesn't have the supports and the control and the supervision which John outlined. John Barry was the founder of the Parole Board back in the 50s. He was also the founder of the Victorian Council for Civil Liberties. John Barry would turn in his grave if he saw that we were suggesting that by denying so many people parole that we're actually protecting the community. What we're doing is avoiding the headlines that might leave the government vulnerable to criticism. If we want community safety, as the wise judge to my left has said, people like that do need supervision in the community. They need to have curfews, they need to be monitored, they need to have drug testing and mental health treatment. But when you're released at the end of your sentence, you're on your own.
Now, if I could ask you some questions, Attorney, in relation to, first of all, the issue about community sentiment and public expectations. Obviously, you've come into office on a tough on crime sort of a platform, and some of the measures that you've introduced legislatively have included, for example, a form of semi-mandatory sentencing for gross violence offenders for young offenders, and also the recent introduction of baseline sentencing. Could I ask you what is the basis for the view that you hold about community expectations not being met?
I think the basis for our sentencing reforms is primarily that we need to restore respect for the law, because respect for the law is a manifestation of our respect for each other. The law is the set of rules that regulates how we relate to each other in a civilised society. If we don't respect the law, we don't respect each other. And certainly the government's view is that the law had become deficient in a number of respects in relation to people's regard for the law and regard for its consequences. That's not to say that we are adopting an approach of locking everybody up and throwing away the key, but we identified a range of areas where we believe the law and sentencing law and sentencing practice had brought respect for the law into a degree of disrepute. I suppose suspended sentences are a classic example of that, and I know many would advocate that they are an effective deterrent. I think our view was that by and large people who got a suspended sentence thought they got away with it, at least for the time being, and tomorrow was another day. So our commitment was to get rid of suspended sentences. So, as we said, jail would mean jail. But that's not to say that everybody who formerly got a suspended sentence would go to jail. But if someone was to be sentenced to a non-custodial sentence, that should be done on the basis of a community-based sentence explicitly imposed. And at the same time, we've reformed community-based sentences to provide a greater range of options to the court, including some of the protective conditions that John Coldrey referred to in the context of parole, things like curfews, no-go zones, non-association orders, so that for those instances where a non-custodial sentence was appropriate, there could be conditions attached that both better protected the community and sent a message to the offender that their actions had consequences and they needed to change their ways.
What about minimum sentencing for gross violence offences, where, for example, you have a case where perhaps a young person has turned their life around over a period that they've been on bail, perhaps having come from very significant social disadvantage? Does that pose a problem, do you think, for the sentencing judge who can see that there's two paths a person might take, and one's going to end up being one of perhaps perpetual recidivism, and there maybe is a chance of reclamation at the point that they're being sentenced, but they're caught by the provision?
Well, gross violence statutory minimum sentences are targeted at particularly horrific assaults, and they are quite carefully specified in the legislation, premeditated attacks, planning in advance to carry a weapon and using some of the horrific crimes that we used to see on the CCTV footage from night spots and so forth. And they, in those instances, we believe it is important to send a very strong message to deter that form of gross violence offending, because the statistics were showing that over the last decade or so, up to our coming to office, crimes against the person were one of the rapidly growing areas of offending. So we wanted to send a very strong message of deterrence, but also incapacitation of those who were prone to that sort of extreme violence. However, it is not mandatory sentencing. We have provided for a range of genuinely exceptional circumstances, but we did want to avoid what happened when the previous government legislated to attempt to get rid of suspended sentences for serious crimes and provided an open-ended exceptional circumstances provision, and the exception became the norm. But we have recognised there can be genuinely exceptional circumstances, and we've provided for it in the legislation.
Now, baseline sentencing seems to be aimed at a general uplift of sentencing in a number of different offences, and presumably that's intended to be attracted to, or more offences are going to be incorporated over time. What is the rationale for the belief that there needs to be higher sentences overall for an array of different crimes, such as, for example, coupled driving?
The rationale is to better protect the community, both through deterrence and through incapacitation. Our view was, particularly with the sentences, most of the sentences for offences that we've included in the initial legislation, that sentencing practice had got well out of line with what was appropriate. To give just two examples, trafficking in large commercial quantities of drugs, or the ice pushers and the distribution gangs that are causing so much distress and suffering, particularly across regional Victoria. Average sentence there, 7 years, maximum life. Under the baseline reforms, that will increase to an average of 14 years. Child sexual abuse, abuse of children under the age of 12, average sentence, believe it or not, 3.5 years for that horrific crime. Under baseline reforms, that will increase to 10 years. We believe those in particular are offences where sentencing practice has got well out of line with what's needed to deter offending and protect the community. But I should say, in relation to baselines, while we are legislating in a way to require an increase in the overall level of sentences, we have sought to do so, and we believe we've achieved the objective of doing so while preserving the existing level of flexibility to the court to determine the relative sentence applicable to the individual offence and offender. In other words, to take into consideration all the current relevant sentencing considerations, but within a context in which the overall level of sentencing for those offences has been increased in line with the baselines.
So the baseline intended for culpable driving is 9 years, is that correct?
Yes, that's correct. I think it's about it's a significant increase on the current level, and that is a very difficult judgment call in relation to culpable driving, because while obviously there's a range of circumstances of offending, and some of it is people with very serious records of previous offending. There can also be instances of people for whom it's a first offence that has had very tragic consequences, indeed culpable driving causing death. Obviously it's beyond careless driving, it's beyond dangerous driving, it's culpable driving in many respects akin to manslaughter. But this was an offence that was singled out by the Sentencing Advisory Council when they looked at baseline sentencing, and their view was that there needed to be a considerable increase in the level of sentence applicable there, simply to predominantly to make clear the gravity of the consequences and to make people realise that culpable driving can cause death, and to make people realise they need to drive carefully when they do get behind the wheel.
Well, we might have a judge in the position, for example, of John Coldrey, lying awake at night, I suppose, wondering whether it should be 7 or 8 years for culpable driving, or 8 or 9. But in terms of, and obviously there's a loss of life involved, but the offender may have had a lapse of judgment that might have happened over a couple of hours of perhaps having some alcohol when they shouldn't and then driving. The 7 or 8 or the 8 or 9, what's the evidence that the 8 or 9 is going to better protect the community when you're putting somebody away, perhaps somebody with no prior convictions, who's employed, who's otherwise a responsible person and has had a singular lapse of judgment that unfortunately has had very tragic consequences.
Well, at the end of the day, all of these matters are matters of judgment. As I say, this was an offence that the Sentencing Advisory Council identified as one where, in its view, there needed to be a substantial increase in the relative level of sentencing. But the other point I'd make, of course, Jane, is that the baseline sets the average or median head sentence for the relevant offence. It is entirely open within that change the overall level of sentencing for the judge to determine the sentence applicable to particular cases. And if you identify a case with a range of mitigating factors and very few aggravating factors, then you'd expect that would incur a sentence substantially below the median. On the other hand, some of the horrific examples that have been reported in the press over recent months and years, if the facts as reported in the press turn out to be the case in court, then you would expect a substantially higher sentence than the baseline.
I presume that you have overall confidence in the judiciary and in the DPP in terms of dealing with the criminal law, and that you would agree with Professor Norden that the criminal law can't be the total solution to crime in the state of Victoria. There's a whole lot of problems that might go in at the front end before somebody ends up before the courts.
I'd make 2 points there, Jane. Certainly, there is no reflection on the roles that individuals are playing within the justice system. The system is not working satisfactorily, and at the end of the day, it's up to Parliament on behalf of the community to set the laws that the courts apply. As the High Court's made clear in recent times, sentencing considerations are predominantly matters of public policy to be determined by Parliament, and for the courts to apply the law in accordance with the law. But in relation to the second part of your question, there is no either or about crime prevention measures and tackling the factors that lead people to offend on the one hand, and on the other hand having effective sentences to deter crime and protect the community. As I said at the outset, the key role of the legal system and sentencing and consequences is that people respect the law and respect one another. But ideally there will be a lot else in our social fabric, in our social capital, that will encourage and support respect for the law and provide people with positive and constructive ways forward in their lives. So it's not a matter at all of either or as between effective sentencing and other measures to deter crime. And as I touched on earlier in relation to community-based sentences and the introduction of community correction orders, one of the objectives of that is to give the court the capacity to sentence particularly younger and first-time offenders to a sentence that is a non-custodial sentence when that's appropriate, but at the same time attach both sanctions, that is consequences such as hours of community-based work that are required, but also to attach restrictive conditions to protect the community, as well as the long-standing conditions relating to treatment and rehabilitation. So if you can avoid sending someone to jail in an appropriate circumstance, and youth diversion is another available option. If you can achieve that and at the same time teach that person to recognise the error of their ways, to find a new and positive direction in life, then that is a highly desirable outcome. But where you need to incarcerate someone in order to achieve the necessary deterrent effect or to protect the community, then that needs to be done, because otherwise it undermines public confidence in the rule of law.
Some of the hardline conservative states of America have moved away from pouring money into prisons and started pouring it into justice reinvestment projects whereby particular communities are targeted for special attention and a more integrated approach. Do you see any value in that, for example, in targeting communities, for example, in Gippsland or in Mildura, where there might be a problem with ICE, with youth suicide or with unemployment, and where perhaps some pilot programs could be run to see if the causes of crime can be tackled before people find themselves caught up in the criminal justice system?
Well, as I've said, it is certainly not a matter of either or between programs and initiatives that will prevent crime and avoid people offending on the one hand, and how the criminal justice system responds when people do on the other. One of the key objectives of the Aboriginal Justice Agreement 3, for example, is to support Koori communities with programs that will assist Koori young people who are at risk of offending. And there are many other similar programs. Clearly a good education and employment opportunities are important for just about everybody in life, and some of the examples of schools that I've had the privilege of visiting have achieved remarkable outcomes in difficult circumstances. My old primary school, for example, St Albans Heights Primary School out in the western suburbs, I visited that a few years ago as part of a back-to-school day, and the principal had lifted that school to a level where I think the kids 4 or 5 years ago were better behaved when I and my cohort was going through. So there's a lot that can be achieved, primarily through leadership of principals and the calibre and dedication of staff, but also, of course, with the available funding, and the state government through negotiations with the previous federal government secured record levels of funding for education here in Victoria. So to repeat the point yet again, it's certainly not a matter of either or, but it is important that the justice system and people's knowledge of the consequences of infringements of the law are upheld.
Now, I think we might go to some audience questions. I just ask the questioners, please, to identify which speaker you would like to address the question to. I can see one a couple down there.
Mr Doyle, Anthony Brown speaking. Can you tell me this?
So was this a question to Mr Clark?
Oh, sorry, yes, Mr Clark. I'm thinking about... Mr Clark, have you got two things? Have you got concerns about the fact that the higher courts are failing to take up the option of correction orders, particularly given that there's been a significant decline and indeed very little use of such orders in the county court, and that the alternative clearly is only jail, given that the government has reduced any realistic sentencing options to CCO or jail? And secondly, in terms of prisons, given that there's 37 beds in this state for psychiatric prisoners at Thomas Embling Hospital, do you think that's an adequate situation, given the prison population and the degree of psychiatric issues in that population?
Okay, on the first part of your question, I think probably the data is a bit too early in terms of establishing patterns or drawing conclusions in relation to how the county court is using community correction orders. You may be aware also that there's currently an application before the Court of Appeal for a guideline judgment in relation to community correction orders, and we'll see whether the court agrees to make such a judgment, and if so, what guidelines they might set. In relation to the prison system, then certainly there has been a substantial increase in the number of persons in custody in recent times. That's predominantly as a result of changes to parole rather than as a result of sentencing changes, simply because of the time lags and periods involved. It's largely been a response of the parole system to the tragedy of Jill Maher and a number of other horrific examples of reoffending by people who are on parole, and the system has been substantially reformed, both legislatively and through restructuring of the Adult Parole Board, but also through changing practice and approach by the board and by community corrections officers, and that has led to substantial increase in the number of offenders who aren't being given parole. I should say, in relation to that, the objective is that people recognise that parole needs to be earned. People just can't coast through the system till they serve out their minimum non-parole period and then expect to get parole. Parole is an important provision in the sentencing system, but it does need to be treated with respect by those who are going to secure parole, both in terms of satisfying the preconditions for it and then in terms of abiding by the conditions of the parole and not thinking they can get away with a lot without any consequences while they are on parole. So the result of that has been a substantial increase in the number of people in custody, and the government has been responding both to that and to the underlying shortage of prison places in the state, and we've been increasing the number of prison places as rapidly as possible. But in the meantime, there are certainly a substantial number of people in custody. We are looking forward to getting additional places constructed as quickly as possible.
I think we're looking for another question at this point. Yes? Have we got a microphone? Oh, sorry, there's one down. Then we'll come back to you. If you could just identify who you're addressing it to, please.
Yes, my question's also for Mr. Clark. Deterrence has been mentioned a few times tonight, and I was wondering why why there is a tendency to talk about deterrence in relation to harsher penalties, when the kind of crimes you're attempting to deter generally don't occur as a result of a cost-benefit analysis. Like a 20-year-old young man who's had 16 standard drinks is out in the city at 3 a.m. and is pissed off for some reason, is not going to be thinking about recent changes to sentencing policy. So I'm wondering why there isn't a focus on addressing some of the broader social and cultural issues such as alcohol, masculinity and violence and stuff like that. Instead, we use deterrence when it's demonstrably not going to work.
Well, as I've said several times, I don't think sentencing and other approaches to deterring and preventing crime are either or. But in relation to sentencing, it is not so much a calculus, it's about getting instilled in people's heads that their actions will have undesirable consequences, and that in the example such as that you give, if a person is on the verge of swinging a punch and thinks, hang on, I better not do this, it might have consequences, however befuddled that might be, then that will make a difference. And if you look, for example, at some of the changes that have been made in Western Australia in relation to penalties for assaults on police officers, that got the message through to people that if you punched a police officer, you could expect to go to jail. And there's been a substantial reduction in assaults on police officers in Western Australia as a result. So it's certainly not a calculus, but it's about getting that message into people's heads, but hopefully not only in a I'd better not do the wrong thing because it might have unpleasant consequences, but in terms of I should be doing the right thing because it is the right thing to do, and it's the way in which I should engage with my fellow human beings in a civilised society. But if people don't believe that the law is to be upheld and don't believe there will be consequences for those who don't uphold the law, a key element of building that respect is missing.
I think we're ready for another question. There's one at the front here. Yeah, just here. Thank you.
Thank you to the Wheeler Centre. Look, a question for the other two chaps, just to give Mr. Clark a break. Two aspects of the system are of concern to me. One is the adversarial system, which seems to drive up costs by having two highly qualified teams arguing the toss when perhaps one could do it. The other disadvantage of that is that one side might be higher quality, and the law sadly depends on how good your particular team of legal advisors are. And the other is the erosion of results because of precedents. Some offender gets a progressive social justice sort of a judge and gets a lower sentence, and then all of the subsequent cases have to be referred in relation to that guy's decision or that woman's decision, as the case may be. Perhaps you could comment on those. Incidentally, I've spent the last 12 months going to the Magistrates' Court following one particular case, and my view of the criminal justice system is it's glacially slow and colossally expensive in terms of taxpayer dollars.
John, you're probably the best person to answer that question. And it's a multifactorial question. But
Well, I don't know about-
I think one of the parts of it was whether you're bound by precedent in terms of a decision of a softy sort of a judge.
Yes, well, the answer to that is you're not. It's always open to the Crown to appeal a sentence if they feel it's been inadequate. But quite apart from that, every day in the courts you'll hear judges say that there's no two cases that are identical. There'll always be something to distinguish the case. So you're not really locked in to a precedent of soft sentence, if in fact it is a soft sentence. As to the law being glacially slow, I hope that's not caused by the judges, although there was a judge who was so slow. At the beginning of the case, counsel would get up and say, does Your Honour have any estimate as to how long this case will take?
Can I say something on restorative justice to answer your question as well? In New Zealand, every case that comes before the Children's Court must have the opportunity of restorative justice, and that's what brings real responsibility and insight from the offender. When the offender hears the victim's story and sits across the table where possible and works out what they can do to bring about healing, and then you get reconciliation and restoration. Now, the victim may not want to be there, but a victim's rep can be there. We need to think of alternatives, because at the moment, in 20 years, the prison population in Australia has gone up 30%, 50% for women. It's gone up at 3 times the national population over the last 15 years. Something's going wrong. We're using the prison system and the criminal justice system incorrectly to deal with dramatic social change taking place in Australia. I mean, 3 times the rate of the national population over 15 years. Not only in this state, last year it was 15% in this state. But, you know, we have to actually deal with the social problems and the social change and not think that armed guards on railway stations and longer sentences throughout the country are going to be the solution. Alternatives must be thought of.
I think we might have time for one more question, and I think people down the back might have missed out a bit, so...
Oh, hello. A question for Mr. Clark again. I'm wondering if you could speak about the role of PSOs. I'm wondering if it's true that they're armed, and I wonder if it's true that they're holding cells that are on stations. Thank you.
Yeah, so thank you for the opportunity, and I'd have to disagree with Peter Norden's disapproval, I take it, of PSOs. I think they have been and will continue to prove to be a very successful reform. They do provide safety at night across the public transport system. They are armed. They do have holding cells available at most, if not all, railway stations. They do have powers of arrest. They have those powers so that they can provide the assurance to people once they're fully deployed across all metropolitan stations after 6 p.m. that whatever station on the metropolitan system you travel to, or indeed large regional centres, that there will be PSOs there. And the anecdotal feedback to date is overwhelmingly supportive of them, and certainly if you look at some of the coverage of them on various TV news bulletins, the support for them is coming in a very large measure from those who might otherwise be considered to be marginalised and vulnerable, from immigrant populations and so forth, and they are saying that they are feeling a lot safer when they are travelling at stations where there are PSOs. And it is all part of rebuilding not only a sense of safety, but a greater reality of safety through providing that assurance. And certainly as a father of children in their early 20s, and I know a similar feeling amongst other parents, if your children are travelling on public transport night, you have greater confidence in their safety. They have greater confidence in their safety because there is ground for that confidence with PSOs at railway stations. So they have the powers they need. They also have the training that they need, the core components for what they do, are undergoing the same training at the police academy as police officers.
I think, have we got time for one more? One more. One more question.
Hi there. So this is again to you, Mr. Clark. You observed that sentencing isn't a mathematical calculus, but one of the criticisms of the baseline sentencing legislation has been that it calls upon a judge to arrive at a sentence and then artificially add to or subtract from that sentence, having regard to the average sentences imposed in relation to a particular offence. What do you have to say to that criticism?
Well, first of all, let me make a correction to what you attributed me in the first part of your question. I was responding to the issue about someone who's inebriated late at night and as to whether or not they would undertake a mathematical calculation. In my view was that, as I said, that wasn't the requirement. The requirement was for them to recognise the potential for an adverse consequence and therefore modify their behaviour. But in terms of baseline sentencing, in effect, what baseline sentencing is doing is substituting an average specified by Parliament in many respects for the role that current sentencing practices play at present. I mean, sentencing effectively is having regard to relativities of one offence vis-a-vis another offence, as well as to absolute considerations. And what it is saying is that the sort of sentence that would have previously received the old median should in future receive the baseline, and sentences that are deserving of offences rather deserving of a sentence greater or lesser than that should receive a sentence greater or lesser than the baseline accordingly. But the factors that are taken into account in working out the overall sentencing gravity of an offence are intended to remain as they currently are. The reforms being introduced in Victoria in consciously intended to preserve the intuitive synthesis approach, and in that respect they're different from, say, the two-stage approach that's been introduced in New South Wales some years ago.
Well, I think that just about is it. An hour goes very quickly when you get into these sorts of discussions, and there's clearly a diversity of views, but it's wonderful to see so many people interested in the criminal justice system and appreciating the complexities of it, and hopefully understanding that most of the people that work within the criminal justice system are genuinely well motivated and conscientious, and I think the Attorney-General would agree with that. So could I ask you to thank our panel, and could I also thank Michael Allen of Liberty Victoria, who did a lot of work to put this event together, and I'd ask you all to consider supporting Liberty Victoria in its attempts to bring about public debate on these sorts of issues. Thank you.